Look at this box. Blur the logo. Remove the text. Strip away every word. You still know the company. That's strange, because what you're recognizing is not a name, not a slogan, not even a symbol. It's a color. And legally, that can change everything. Now, to be clear, no company literally owns blue. Colors are not land. Nobody gets a deed to a wavelength of light. But in the right context, after enough time, enough advertising, and enough lawyers, the law can get surprisingly close. This is the story of how that happened, and why the line between protecting a brand and claiming a color is thinner than it probably should be. For a long time, courts were deeply skeptical that color alone should count as a trademark. That made sense. A trademark is supposed to tell you who something came from. A word can do that. A logo can do that. A shape sometimes can do that. But a color just looks like a color. And there was a bigger problem: supply. If one company gets exclusive rights to a color, what happens to everyone else? You can invent a new brand name. You can design a new logo. But the visible spectrum is not getting any bigger. This concern had a name: color depletion. Let one company claim one shade, then another claims another. And slowly, useful colors get fenced off. Not because anyone invented them, but because someone got there first with a legal department. For decades, that argument carried real weight, not because every judge thought color trademarks were impossible, but because they thought the idea was dangerous. Then the rules started to wobble. A few courts began to accept a narrow possibility. Maybe color could work as a trademark sometimes, if customers had learned to associate that color with one particular source. Not because the company declared it, because the public did. That distinction matters. Trademark law is not supposed to reward originality. It is supposed to prevent confusion. So the question slowly changed. From, can anyone own a color, to, can a color, in the right setting, act like a brand identifier? And in 1995, the Supreme Court answered that question. The case was not glamorous. It was about dry cleaning equipment. A company called Qualitex had been selling press pads in a distinctive green-gold color for years. Then a competitor started selling very similar pads in a very similar shade. Qualitex sued. And the case reached the Supreme Court with a deceptively simple question: can a color, by itself, function as a trademark? The court said yes, unanimously. Its logic was straightforward. If customers have come to associate a particular color with a particular company, then that color is already functioning as a source identifier. Refusing to protect it would not preserve common sense. It would ignore marketplace reality. The court was also unimpressed by the old color depletion argument. In effect, it said, there are lots of colors, and trademark law already has limits. Not every color qualifies. Not every use counts. And if a color is genuinely necessary for the product to work, then it is functional, which means it cannot be monopolized through trademark law. That last part matters. A company cannot trademark orange for safety cones because orange makes safety cones easier to notice. That would not be branding. That would be appropriating usefulness. But with Qualitex, the big principle was now established. A color alone could sometimes be protected. And once that door opened, companies rushed toward it. Luxury brands, telecom giants, consumer product companies all saw the same opportunity. If a color could become a brand asset, then a color could become territory. Tiffany became strongly associated with its robin's egg blue packaging. UPS leaned hard into brown. T-Mobile made magenta part of its corporate identity. And on paper, the rules seemed reasonable. A company could not just point at a color and claim it. It had to show three things. First, customers actually associated that color with that company. Second, the color was not functional. And third, protection was limited to specific goods or services, not reality as a whole. That sounds narrow, and sometimes it is. But there is a difference between a narrow legal theory and an aggressive enforcement strategy, because trademarks are not just definitions, they are weapons, and weapons get used. Once a company convinces a court, or even just convinces its competitors, that a color is part of its brand, the next fight is no longer about principle. It is about boundaries. How close is too close? How much similarity is confusion? At what point does inspired by become call the lawyers? Those questions do not have scientific answers. They have expensive ones. The most instructive example is not a tech company. It is a chocolate bar. Cadbury had spent generations teaching consumers to associate chocolate packaging with one particular shade of purple. So naturally, it tried to lock that association down in trademark law. And this is where the whole system reveals its real obsession, not color, but description. Cadbury's problem came down to one word: predominant. Not purple covering the whole package, not purple in one fixed arrangement. Purple as the predominant color of the packaging. That sounds precise enough, until lawyers get involved. Because predominant does not describe one exact visual result. It describes a range, a family of possibilities, a moving target, and courts do not like moving targets. So after all the history, all the recognition, all the brand value, Cadbury ran into the same problem that keeps appearing in color trademark law. The fight was no longer about the color, it was about the sentence. And that really is what trademark law is trying to protect, not the color itself. The mental jump, the instant from "I see this" to "I know who that is." The strangest example might be Christian Louboutin. People often say Louboutin owns Red. That is not true. What the company won was much narrower and much weirder. It secured protection for a red lacquered sole when that red sole contrasts with the rest of the shoe. So red sole, different colored upper, potentially protected, entire shoe red? Different story, which means Louboutin does not own red in the abstract. It owns red in one particular place, under one particular visual condition. Not just a color arrangement, a relationship, a contrast. That is where this area of law starts to get philosophically slippery. Because the closer you look, the less these cases are really about color itself. They are about conditioned recognition inside the viewer's brain. The law is not protecting blue. It is protecting the split-second mental jump from "I see this" to "I know who that is." And to be fair, that solves a real problem. Counterfeits exist. Knockoffs exist. Consumer confusion is real. If a company spends decades teaching the public to associate a particular visual cue with its products, there is a legitimate argument that competitors should not be allowed to free ride on that work. That is the best case for color trademarks, but there is also a cost, because this system has no obvious natural stopping point. The broader the association becomes, the stronger the legal claim becomes. And the stronger the legal claim becomes, the more tempting it is to stretch it. From one precise shade to nearby shades. From one narrow product category to adjacent ones. From preventing confusion to discouraging similarity. The law says colors can be protected. It is much less clear how far that protection should reach before it stops feeling like trademark law and starts feeling like private ownership of the visible spectrum. So no, companies do not literally own colors, but sometimes they can own something uncomfortably close. Your expectation, your recognition, that tiny flash in the brain that says, before you read a word, I know what this is. That is the real asset. And once the law decides that instinct has commercial value, someone will try to measure it, define it, and defend it. Which is how we ended up in a world where light still has a wavelength. But in the right courtroom, it can start to look a lot like property.